Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. We come to you today to break down the January 20th, 2026 opinion in Ellingburg versus United States. We previewed this case and delivered oral argument coverage. Listen to that episode if you want to learn more about this case.
In a unanimous 9-0 decision, the Supreme Court held that restitution under the Mandatory Victims Restitution Act, which we'll call MVRA, amounts to criminal punishment for Ex Post Facto Clause purposes. Justice Kavanaugh authored the majority opinion. Justice Thomas wrote a concurring opinion joined by Justice Gorsuch that called for sweeping reform of ex post facto jurisprudence. The Supreme Court's ruling ensures that defendants like Ellingburg can challenge restitution orders imposed retroactively under laws enacted after their crimes occurred.
Before advancing, let me pause here to remind you to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, let's walk through Ellingburg versus United States, a case where all 9 justices agreed on the outcome but revealed competing visions for how ex post facto protections should operate in America. Ellingburg committed his crime before April 24, 1996, when Congress enacted the MVRA, despite committing his offense before the law took effect. When Ellingburg got sentenced later that year, the court ordered him to pay $7,567.25 in restitution under the new MVRA provisions. Ellingburg never satisfied that obligation. Think of it like Congress changing the rules after the game ended.
Years later, Ellingburg realized he might hold grounds to challenge this restitution order on ex post facto grounds. Ex post facto comes from Latin, meaning after the fact. Ex post facto laws retroactively change the legal consequences of acts committed before the law's enactment. The U.S. Constitution generally forbids ex post facto laws for criminal laws, but not for civil laws. Let me give you an example. Let's say Congress passes a law that makes it a felony for people to talk on their cell phones in the car. One day, after the law becomes effective, you get arrested for talking on your cell phone in the car 3 years earlier. The Constitution prevents your conviction because you committed the act before Congress made it illegal.
Here's another example closer to Ellingburg's situation. Let's say Congress passes a law requiring convicted bank robbers to pay $50,000 in restitution to victims. You robbed a bank last year when no restitution law existed. If Congress tries to apply this new $50,000 requirement to your old crime, the Constitution might protect you, but only if courts consider restitution to be criminal punishment rather than civil compensation.
That's exactly Ellingburg's problem. He committed his crime before the Mandatory Victims Restitution Act took effect. When courts later ordered him to pay restitution under the new law, he argued this violated the Ex Post Facto Clause. But here's where things get complicated. Courts must first determine whether restitution actually constitutes criminal punishment or merely a civil remedy designed to compensate victims.
If restitution counts as criminal punishment, Ellingburg gets constitutional protection. If courts treat it as civil remedy, he loses that protection entirely. The Eighth Circuit concluded that MVRA restitution did not qualify as criminal punishment, following circuit precedent that characterized such restitution as civil rather than criminal. This created an unusual situation because both Ellingburg and the United States agreed the Eighth Circuit got it wrong. When both parties seek reversal, the Supreme Court appointed John F. Bash as amicus curiae to defend the lower court's judgment.
Justice Kavanaugh wrote for a unanimous court joined by Chief Justice Roberts and Justices Thomas, Alito, Sotomayor, Kagan, Gorsuch, Barrett, and Jackson. The court held that restitution under the MVRA amounts to criminal punishment, not merely a civil remedy, for ex post facto clause purposes. Justice Kavanaugh emphasized statutory text and structure analysis. When determining whether a law violates the ex post facto clause, courts must evaluate whether it imposes criminal sanctions versus civil remedies. This requires examining the law's text and structure to understand congressional intent.
The majority found overwhelming evidence that Congress intended MVRA restitution to impose criminal punishment. First, the MVRA explicitly labels restitution as a penalty for a criminal offense. Second, only criminal defendants convicted of qualifying crimes face restitution orders. Third, courts impose restitution during sentencing proceedings alongside other criminal punishments like imprisonment and fines. Fourth, the government, not victims, serves as the adverse party at sentencing.
The statutory structure reinforced this conclusion. The MVRA appears in Title 18, Crimes and Criminal Procedure. The main authorization sections fall within Chapter 232, Miscellaneous Sentencing Provisions. Courts must follow federal rules of criminal procedure when imposing restitution. The U.S. Sentencing Commission must promulgate criminal sentencing guidelines for restitution.
Most tellingly, defendants who fail to pay restitution face potential imprisonment if courts determine alternatives to imprisonment are not adequate to serve the purposes of punishment and deterrence. This consequence definitively demonstrates criminal rather than civil character.
Justice Kavanaugh noted that Supreme Court precedents consistently treated MVRA restitution as criminal punishment. In Manrique v. United States, the court stated that the MVRA requires courts to impose restitution as part of the sentence. In Pasquantino v. United States, the court explained that MVRA restitution gets designed to mete out appropriate criminal punishment.
The majority distinguished Smith v. Doe, which found sex offender registration requirements civil, noting that case involved distinctly civil procedures, while MVRA restitution bears all the hallmarks of criminal punishment. The court acknowledged Congress intended MVRA restitution to compensate victims, a non-punitive goal, but held this dual purpose did not negate the criminal punishment character. The statutory text and structure demonstrated Congress intended to both punish and compensate, and so long as the law shows intent to impose punishment, that ends the inquiry.
While victims receive notice and consultation in MVRA proceedings, they cannot initiate or settle the restitution process independently as they would in civil proceedings. This limitation distinguishes MVRA restitution from purely civil remedies.
Justice Thomas, joined by Justice Gorsuch, agreed with the outcome but wrote separately to propose fundamental reform of ex post facto jurisprudence. Thomas argued the court should return to the original 1798 understanding from Calder v. Bull. Thomas traced ex post facto protection to the Founding Fathers' belief that retroactive punishment laws violated fundamental principles. James Iredell called such protection the most essential right of all, while Alexander Hamilton placed the prohibition of ex post facto laws among the greatest securities to liberty and republicanism.
Justice Thomas attacked the current legal framework as fundamentally flawed. The modern approach uses two tests with 12 combined factors to determine whether laws constitute criminal punishment. Thomas saw this framework manipulable, allowing legislatures to evade constitutional protection through labeling and semantics, convoluted, creating unpredictable, multi-factor balancing tests that invite arbitrary discretion, and ahistorical, departing from original constitutional meaning. Thomas argued that when Calder limited ex post facto clauses to laws imposing punishment for crimes, it referred to established legal categories. Crime meant public wrong under English common law, which divided unlawful acts into private wrongs, injuries to individuals, and public wrongs, injuries to the sovereign. Public wrongs included any offense against sovereign authority, regardless of formal criminal or civil labeling. Punishment meant coercive penalty, any deprivation of life, liberty, or property imposed to redress public wrongs. The analysis focused on what the law does, not how the legislature labels it.
Under Thomas's approach, ex post facto clauses would apply to any retroactive law that imposes coercive penalties to redress public wrongs enforced by the sovereign rather than private parties.
This framework would extend ex post facto protection to civil penalties for public offenses, administrative agency enforcement proceedings, municipal sanctions like speeding tickets, and any government-imposed sanctions for violations of public law.
Thomas cited extensive historical precedent showing courts once distinguished between punishments imposed in response to public offenses, whether prosecuted criminally or civilly, versus purely private disputes. Early cases held that laws could not evade ex post facto analysis by giving a civil form to that which is essentially criminal.
This decision resolves the circuit split about MVRA restitution in favor of defendants. Federal courts disagreed about whether such restitution constituted criminal punishment, with some circuits applying ex post facto protections and others refusing. But the practical impact for most defendants remains limited. Even with ex post facto protection, defendants must still prove their specific restitution orders violate constitutional prohibitions against retroactive punishment. Courts will examine whether defendants received restitution orders under laws enacted after their crimes occurred, and whether those laws increase punishment compared to pre-existing law.
The unanimous decision reflects careful attention to statutory text and structure, showing how seemingly technical legal questions can have major consequences for thousands of federal defendants seeking to challenge restitution orders.
But Justice Thomas's concurrence signals potential future challenges to the entire framework governing when laws constitute criminal punishment for constitutional purposes. His call for fundamental reform could eventually reshape ex post facto jurisprudence far beyond restitution cases.
The decision also demonstrates the court's willingness to scrutinize government labeling of sanctions as civil when their actual operation appears criminal in nature. As Justice Thomas noted, today's civil penalties often include confiscatory rather than compensatory fines, forfeiture provisions that allow homes to be taken, remedies that strip persons of their professional licenses and livelihoods, and the power to commit persons against their will indefinitely.
This ruling ensures that defendants cannot lose constitutional protections simply because Congress labels punitive sanctions as civil remedies. The court looked beyond formal labeling to examine the actual operation and consequences of the law. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.